Hello, everybody. Welcome along to today's talk. We're very, very privileged to have a very distinguished speaker with us today, Morton Halperin. He's a former director of policy planning at the U.S. State Department. More interesting to me, at least, is that he was once on Richard Nixon's enemies list, which is quite a distinction to have. Unless you've been on planet Mars, you will, of course, know that Japan, under the Abe government, is trying to pass a secrecy, has passed a secrecy law, which comes into effect at the end of this year. The law has been condemned by a very wide range of organizations, including the International Federation of Journalists, the Federation of Japanese Newspaper Unions, the Japan Federation of Bar Associations. Many other watchdogs believe that the law is fundamentally flawed. One of its problems, among many, is that it potentially criminalizes journalists in the course of their work. Our speaker today, Mr. Halperin, has also condemned the law in the strongest terms. He says, quote, "The law is about as bad as any that a democratic government has considered in the 21st century." I've just asked him if I wrote this notice, if I accurately quoted him. He said, it's an accurate quote, and it's an accurate description of the law and its flaws. He is going to talk today for about 15 minutes, and then we will take questions, and let's hope we have an interesting discussion. Can I remind you, please, if you haven't already done so, to switch off your mobile phone? Thank you.
Thank you very much. It's a pleasure to be here. Let me talk briefly about a few aspects of this secrecy law. And I start with the assumption that this is not a technical issue. This is not a minor question. It's something that goes to the heart of a democratic society. Because all governments have a tendency to keep everything secret, even things that are essential to public understanding of key issues, all of us citizens of democratic countries are dependent on the press to ferret out information and to publish it, whether they're bloggers or newspaper reporters or TV journalists. And therefore, laws which chill both the willingness of government officials to talk to reporters and reporters' willingness to write stories is an extraordinary threat to the public's right to know and to the ability of governments to function in an effective democratic way. And that understanding has now been reflected in the laws and the court decisions of a number of international tribunals, a number of national courts. The basic principle is that information belongs to the people of a country, not to its government. And the government has an obligation to make it public either on its own or when requested, unless there is a compelling reason to keep it secret. And national security, of course, can be such a compelling reason, but only if the statute specifies very clearly, as this one does not, what is the information that needs to be protected and provides procedures for challenging the decisions about what needs to be protected. So that when a government is considering enacting legislation in this area, I believe it has an obligation to proceed slowly, to proceed carefully, and to fully consult with the citizens of its country, with its legislature, and with experts from around the world, because we now have an emerging global consensus of what these rules can be. And by consulting around the world, you learn about what's going on in particular countries. Now, several years ago, South Africa began the process of enacting a secrecy law. It was as controversial as this one, but the difference is the South Africans spent 3 years in enacting this law. It went through several revisions. It still came out with things that civil society did not like. Civil society has never seen a secrecy law that it likes. But it was substantially improved because the South African government did what the Japanese government did not do. It consulted with its own citizens. It consulted with its opposition political parties. And of course, the South African parliament is even more dominated by the government party than is the Diet. But nevertheless, they consulted intensely. They consulted with international civil society. I was there twice, met with senior officials of the South African government, had a chance to explain to them what the international principles were. We were then, in fact, in the process of drafting what became the Zhuhai Principles. That was not done here. In the United States some years ago, Congress wanted to, the administration wanted a law making it a crime for a government official to reveal the identity of a covert CIA agent. You would think that would be straightforward and not controversial. There were 3 years of congressional hearings. I testified 6 times myself about this law in both houses of the Congress. It was rewritten time and again, and by the time it was enacted almost unanimously with the support of the American Civil Liberties Union and the CIA. That's the kind of process that ought to be followed and was not followed here. Let me say one other thing about the procedure. The Japanese government, I understand, is saying that it had to do this because the U.S. government was refusing to provide information to the Japanese government on key issues. I have myself deep personal experience on this issue. I started working in the U.S. government on U.S.-Japanese relations in the 1960s, and I was involved in a number of decisions then and in later years, including in the last Bush administration and the Obama administration, about what information could be provided to the Japanese government, particularly on the issue of nuclear weapons and nuclear strategy, about as sensitive an issue as one could imagine. And in those discussions, and then the many times which I advocated and got government agreement to provide information to the Japanese government, to consult fully with the Japanese government, no one ever said we could not provide that information because the Japanese secrecy law is not as good as the secrecy law in other countries. Now, that doesn't mean that there wasn't some person in the U.S. government who said to some person in the Japanese government, you ought to tighten up your law. Those same people say the same thing to the American government about its law. But the notion that that was a fundamental impediment to consultation between the two governments on issues of most importance to their security, I just submit is absolutely wrong. The statute itself has a number of weaknesses that you've heard about. It penalizes the press in certain circumstances. It claims to protect the press, but it does it with fuzzy language about when the press can be subject to criminal penalties, and that, I think, will have a chilling effect on what reporters are prepared to do. They don't know what inappropriate conduct means. And it violates the Zhuhai Principles, which were developed by a group of international organizations and NGOs, which has been endorsed by the Council of Europe, among other entities, and which basically says no reporter should be subject to criminal penalties. No person who doesn't have a security clearance should be subject to criminal penalties. This statute violates that, and it also provides excessive criminal penalties, far longer than most allies of the United States, for release of classified information by government officials. It also denies government officials what they have by statute or by legal interpretation in most other countries, which is a whistleblower defense that they were revealing corruption or illegal activities, or a public right of knowledge defense, which says that the value of the information to public debate outweighed the harm to national security. Both of those should be in any statute that deals with the release of information. Moreover, there needs to be a much more precise requirement for determining which information can be classified and why and for how long. In the American system, for example, not only do you have to indicate whether it's foreign relations information or information relating to national defense, but you have to specify when you classify information exactly what the harm is that you're protecting against by classifying the information. And then you have to give either a date or an event after which the information would be made public. And that, again, is lacking in the Japanese law. We also have several mechanisms in the American law to appeal decisions to classify information, including something that's turned out to be highly effective, which is an interagency review committee, which has often overruled an agency and ordered the release of information. So that I would say any government, including the Japanese government, has a right to enact statute making it a crime for a government official to release information. It has a right to specify and needs to specify with precision what that information is. But this law falls very short of that. And I would hope the Japanese government would go back and take another look at this before December when it goes into effect. Look at the international standards in the Zhuane principles and consider them one by one. It may decide some of them are not accurate and not appropriate for Japan, but I think every democratic government has an obligation to its citizens to look at the best practices that are reflected in the Zhuane principles and to justify to its public explicitly, not to simply dismiss the principles as written by civil society as if civil society is not important in a democratic country, but to discuss the substance of the principles and to justify any deviation from them. And with that, I'll stop and take questions.
Thank you. Have you had a chance to convey those concerns directly to anybody in the government here?
I have not been invited to do so. I would certainly welcome an opportunity to do so.
Thank you. Well, we'll open it up to questions. Working press here in the middle first, and then to the rest of the audience. Who's going to be first? Martin? You saved him from a question from me, Martin. Can I remind you just to state your name and your organization at the microphone?
Martin Kölling with the German financial daily Handelsblatt. A question, I don't know whether you are willing or able to answer it, but why do you think the Japanese government pushed this law through? Because they could, or because they had the opportunity to do so? Why is that?
I just should add, there's some speculation that one of the reasons is because they were concerned about how people were reporting on nuclear power. That's one of the...
Yeah, I mean, I think that it's clear that's going to be a contentious issue going forward, whether information about nuclear power can be classified. I really don't know. I certainly don't have any sense that there was a new big push, even from a particular part of the U.S. government, nor that there was any issue of a particular kind of information not being shared from the U.S. government. So my suspicion is that this was on a long-standing agenda, and that they came back with a big majority and decided to do it. But I don't really know.
Anybody else with a question?
Little freelancer from Germany. I think there is now really a parliamentarian control of what's secret and what's not. How is the control in US? How does it function? Does the parliament control what should be secret and what's not?
It's complicated. The secrecy law in the United States is the Freedom of Information Act, which provides that information should be made public either proactively or on request unless it meets certain designated categories that Congress has said can be kept secret. But as to how to define what is appropriately kept secret in the name of national security, Congress has delegated that authority to the executive branch. So what the statute says is information properly classified pursuant to an executive order. And presidents have issued an executive order on classification, which lays out how information should be classified and what the standards are, what kinds of harm have to be developed. So they're in the executive order on classification. Then separately, there's a statute which is very contentious, which is called the Espionage Act, but which the government has nonetheless used in 9 cases, 6 of them by the Obama administration, to indict government officials or journalists not journalists, but government officials or private citizens in one case, for revealing, publishing information relating to national security. The standards in the American Executive Order identify categories: war plans, communications intelligence, foreign relations, diplomatic negotiations, and then specify specific kinds of harm underneath each of those. But that's done in the executive order, not by the Congress.
I saw this hand at the back first, then Richard, then this gentleman here.
Süddeutsche Zeitung, Germany, Neidhardt. You probably, our error, all our error is probably to treat Japan as a democracy. But that's not my question. As you already mentioned, one justification is the pressure from the US, especially from the Pentagon. To what extent do you think it is true that American Japan policy is dominated by people in the Pentagon?
Well, I served in the Pentagon twice, so I'm not sure. I don't necessarily think that's a bad thing. I just do not accept the notion that people in the Pentagon believe that Japan needed tighter secrecy laws. And let me give you a recent concrete example. I served on something called the Perry-Schlesinger Committee, which was a congressionally mandated committee appointed by the Congress during the Bush administration to look at the nuclear strategy of the United States. One of the recommendations in that panel report was that the United States ought to intensify its discussions with Japan about nuclear policy, and that those ought to be as intimate and intense and as detailed as its discussions with NATO countries were. We discussed that recommendation with senior officials of the Bush administration, including the Pentagon. They all reacted to it that it was a very good idea and one that they would implement. Not a single person said to us, we can't do this because Japan does not have a secrecy law. Then the Obama administration came in. The staff director of the Perry-Schlesinger Commission became the person in the Defense Department who worked on the nuclear posture review and was in charge of consultation with other governments about the nuclear posture review. And since this law was passed, I went back to him again just to make sure I had not misunderstood and said, isn't it true that they had implemented the recommendation of the commission? He said, absolutely. Not only did we consult fully with the Japanese government in developing the nuclear posture review, but for the portion of the review dealing with U.S. extended deterrence in Asia, we developed that part of the report fully in consultation with officials in the Japanese government. We wrote it together, was his description of what's been done. And again, there was no sense, no hint that there was a problem here. So it may be that officials in the intelligence agencies pressed on the secrecy issue. They think the United States needs much tougher secrecy laws. I would be astonished if it was officials in the Defense Department, and I know to be a fact that on the most sensitive subject, which is planning for the use of nuclear weapons and nuclear deterrence, that the United States has fully and completely consulted with the Japanese government just a few years ago.
Richard?
Richard Lloyd Parry of The Times. At the moment, this law is something of an abstraction because it's just a piece of legislation that has not yet gone into force. So in order to help us to understand it better, could you sketch out a scenario, some kind of imaginary scenario, in which this law might figure in ways that were obviously unjust and damaging to the public interest?
Well, I think the nuclear power issue is a good one. And governments all claim the right to classify certain information about nuclear power plants. That's information that would be helpful to a terrorist trying to blow up the nuclear power plant. But it's hard to define precisely what information is in that category and what is information that the public is entitled to know. And for that reason, the Joinet principles say that information that's essential to public understanding of a critical issue, such as environmental safety, cannot be classified, even if you can make an argument that it would cause some harm to national security to release it. This Japanese secrecy law has no such provision. And so if a government official was asked a question by a reporter relating to the current state of the nuclear power plant, that government official might fear, once the statute came into effect, that because some of the information about the plant has been designated as secret information, that he or she could be arrested and tried under the statute, sent to prison for 10 years, because he or she handed that information to the reporter. And a reporter who was trying to get that information might well fear that by encouraging the government official to release it, by saying to the government official, in effect, even if it's stamped secret, the public is entitled to know it, that they were using, I forget what the words of the statute are, inappropriate means to gather the information. Now, the problem is that long before anybody is indicted, there is a danger that this has a chilling effect on the conduct of people, and that government officials will be less willing to talk to journalists. Journalists will be less willing to press government officials. So we could go years without an indictment and yet later discover that there were many cases in which information did not appear in the press that would have appeared in the press, but for this fear that people have that the statute would be used against them.
Some of the people in this room interviewed, for example, nuclear power plant workers when we were trying to figure out what was going on at the Daiichi power plant. Obviously the names weren't revealed, and they were in breach of TEPCO's policy, confidentiality policies, by talking to us. Could that be one of the scenarios you're talking about?
Well, I actually haven't looked at that position closely, but I think it has to be government information.
I see.
So, and the information that's been classified by the government. But presumably now, most of the information about that plant and its safety is government information, because the government has taken, as I understand it, major responsibility. So probably the information in the first few days would not have been covered, but by now it would be.
This gentleman here, then Teddy, then Larry. Yeah.
I'm Daniel Eskenazi, freelance journalist from Switzerland. In what sense do you think this law could be linked with what happened to Edward Snowden and to the US? And I wanted to have your point of view on this affair.
Well, the Snowden affair is very interesting because it's complicated. He revealed information which I think almost every American believes should have been made public. For example, he revealed the fact that the number, the duration, the calling number, and various other information, not the content, but all the information about every single phone call made in the United States was turned over to the National Security Agency, and all of it was kept by the National Security Agency for 5 years. And much of it, and lots of it that had nothing to do with people suspected of terrorist attacks, were put into the NSA data bank and kept there permanently. I think most Americans believe that they were entitled to know that. And most of them, it turns out, believe that it should not be done. And so the Congress, with the support of the president and the reluctant acquiescence of the intelligence community, is about to end that program. And so we now know that that program was able to exist only because it was secret. And clearly it is not justified to keep a program secret because you know if you make it public, the public will stop you from doing it. So if Snowden had only released 2 or 3 things like that, I think he would be a hero to almost everybody in the United States. What makes it complicated is that he's also revealed other information, like what the United States knows about the cyber warfare capabilities of the Chinese government, that most Americans think should not have been made public. He also had this strange habit of going to unusual places, let's say, to hang out, to Hong Kong and then to Russia. But he's also served, I have to say, another important function. People have criticized him for not using the whistleblower procedures in the American law. And what he's pointed out is that the whistleblower procedures don't apply to contractors, and he was a contractor and not a government official. So he was not entitled to the protection of the whistleblower statute. He has said that he actually went to 15 different people in the chain of command, told them about these things, and they all did nothing about them. He also has pointed out correctly that in the American law, he does not have the right to a defense that the information he revealed was essential to public debate, a defense he clearly could make about at least some of the information. And therefore, he has said he will not come back to the United States and say in trial that he would do that if he had a whistleblower's defense, a public interest defense, but that he doesn't have one. And that's also stimulated a debate in the United States about extending the whistleblower defense to contractors and adding into the statute what the Joinet principles say is essential, which is a defense that the information you reveal was more important to public debate than any potential harm that might come from the information. So he's a very controversial figure, more, I think, in Germany even than in the United States, but in the United States as well.
I think, if I understand you, the question was asking you if you think the fear of another Snowden in Japan triggered that law.
Oh.
Yeah.
Well, I think what Snowden demonstrates is having a law doesn't stop this from happening. I think, if you go back to our first big whistleblower, Daniel Ellsberg, he actually thought the law was much worse than it was and expected to go to prison and was astonished when he was told that actually the law was very ambiguous and that nobody at that time, Daniel Ellsberg was the first person in the United States indicted for giving information to the press. There'd never been such an indictment. He had no idea that that's true and no idea that the statute was ambiguous because the U.S. government, to put it gently, lies to everybody who becomes government official. You're given a piece of paper that says, I understand that there is a statute that makes it a crime for me to reveal information to the press. And in order to get a security clearance, you have to sign that. I used to change it to, I understand I've been told that that happened. And then many years later, one of the security guys I dealt with was confronted with somebody else who says that. And he said, nobody since Halperin has asked that. And the guy said, I'm Halperin too. It was my son. And he raised the same objection to it. But so for somebody who feels as strongly as Ellsberg did and as Snowden did about the thing being wrong, releases it expecting to run the risk of criminal penalties. So I don't think you deter those kind of people by this. Moreover, there's no evidence, and I think no reason to believe that the German government is doing something at that kind of scale.
Teddy. Larry, did you still have your hand up? Okay.
Hi, I'm Teddy Jimbo with videonews.com. Can you enlighten us with this executive order 13526, I believe, which was passed by, presented by the President Obama in 2009? What, if we can just sort of highlight what part of the previous executive orders were tightened by this order.
I'm not sure I know. Is this the one on classification or the one on television?
Yeah,
on classification.
Yeah, and what would be the fundamental difference between the U.S. standards set by this executive order and the Japanese secrecy law? And one last follow-up to the previous question. In a country which seemed to have a very strict rules on classified information, still could happen, still could have NSA affair. So I had a difficulty relating that. So if you could just also enlighten us on that. Thank you.
Yeah, well, the Obama executive order, as I understand it, made it harder to classify, not easier to classify. It tightened up the requirements for specifying the harm. It reduced the number of years that you can keep things secret. And it went, when the Republic, because these are presidential executive orders, they change every time we have a change in administration. And one of the changes is to go from shall to may. That is, under Republicans, the executive order says information whose release could reasonably be expected to cause harm to the national security shall be classified. And under the Democrats, the executive order says information that whose disclosure could reasonably be expected to cause harm to national security may be classified, emphasizing that government officials have a right to release information even if it reasonably could be expected to cause harm, precisely if, as the executive order says, they determine that the public interest in the information is greater than the harm that could be expected to national security. But the American executive order requires, as I've said, this precise description, and the information has to be put on the document, and it has to be put paragraph by paragraph, which is also not in the Japanese order. So in the United States, under the Obama executive order, you have to classify a document. You can't just put a stamp on the whole document, say top secret, and maybe 30 years from now will we consider it, which as far as I can tell you can do under the Japanese executive order, but which could be fixed by the administrative regulations, which as I understand it need to be issued before December. Under the American executive order, you have to deal with the document paragraph by paragraph, and you have to mark each paragraph separately. So the paragraph, even if the document is stamped secret, there are many paragraphs that are marked unclassified. And some may be marked confidential, some may be marked secret, some may be marked top secret. But then you also have to identify for each paragraph which portion of the executive order you're classifying the document based on. Is it because it's communications intelligence? Is it because it's war plans? Is it because it's information about manufacturing weapons? Is it diplomatic negotiations? They each have a category, C3, C4, C5 in the executive order, and you have to list which category the information is in that justifies the classification. And then you have to explain in a sentence why the release of this information would cause harm to national security. And then you have to say, this can be released in 5 years, or when somebody dies. There was once an American document on France after de Gaulle, and it was classified. And the reason was that de Gaulle believed he was immortal, and therefore a document that suggested the American government believed he wasn't immortal would harm French relations with France. And so it could be released after he died. So you have to specify either an event or a series of years before the information can be released. The American executive order also invests in senior officials the authority either to not classify information or to declassify information if they determine its release could cause harm to national security. It also requires much tougher standards and much heightened requirement of harm to extend information beyond 30 years. So none of, as far as I'm aware, none of those provisions now exist in the Japanese law. They all could be put in the law by administrative direction and would go a considerable distance to dealing with at least some of the problems with the law.
Larry? And then gentleman again.
My name is Larry Rapetta. I teach law at Meiji University. Regarding, David, your earlier question about TEPCO, of course, because TEPCO is not part of the government, it's not subject to information disclosure laws, has no obligation, and I believe that's one of the reasons that the government keeps TEPCO alive. But I have two questions for Mr. Halperin. The first is, I would love to show you the stacks of newspaper clippings I have from the autumn of last year, where you have, in particular, the Chief Cabinet Secretary, Mr. Suga, who is the senior spokesperson for the Japanese government, saying again and again, we need this law because we need to exchange defense-related information with other countries. And of course, other countries means the United States. So your earlier comments that this has not been a problem completely contradict what the Japanese government has been telling the Japanese people. They've been saying, we need this because the U.S. demands it. That's one of the key messages. A second thing he said was, we need this because we're creating a new National Security Council. And there was a separate law which was passed at the same time. It was considered by the Diet at the same time. They were thought to be sort of very closely related. And so the government said, we need the secrecy law because we're creating this National Security Council. And I'd like to hear your comments on that. Apparently, prior to that, Japan did not have something labeled a National Security Council. What's the significance of that? And just related to that, the second question is on a somewhat different topic, but of course, I think for most of us, the biggest issue related to secrecy concerns is national security. And of course, Japanese national security is completely bound up with the U.S. relationship. And as you know, certainly one of the areas of greatest friction, ongoing friction, is in Okinawa, and it's the local opposition to the U.S. military bases there. And in particular, related to a marine base, there's the base of Futenma in the city of Ginowan, and there's a proposal to build a new runway in the north. Could you make any comments about whether these developments are necessary, and what is the role of the United States Marine Corps, and does the American government need to maintain them in Okinawa?
Those are big questions.
So, on the creation of a National Security Council, I don't see any harm in that. It doesn't require a secrecy law. There's, I think, a lot of confusion about the National Security Council in the United States. The National Security Council was created right after World War II and was designed to be a mechanism to formalize the process by which the State Department and the military departments were talk to each other. And it also created the Defense Department. Up until that time, the United States had a War Department and a Navy Department. The National Security Act created the Defense Department and created the National Security Council. And it came from a time in which there was no tradition of these agencies talking to each other. The State Department was engaged in diplomacy. The Defense Department was engaged in fighting wars, and there was very little intercourse between them. The post-war period marked a fundamental change in the way those relationships worked, so that day to day now, the departments have to interact in what they do, and the Congress was trying to force them, in effect, to interact by creating the National Security Council. Truman announced that it was none of the Congress's business. Of course, being Harry Truman, he said it was none of their damn business. And he refused to convene meetings of the National Security Council. And he said that the Congress cannot tell him who to bring into a room when he wants advice. And so the National Security Council never met. The president convened the people he wanted to convene. Often it looked like it was the National Security Council, but it wasn't. And that's been true of every president. Every president creates his own set of officials that he wants to consult. Every once in a while, somebody says, oh, we better have a National Security Council meeting. And so somebody gets out a textbook and discovers who's actually on the National Security Council and who's not. Nobody in the government actually knows. And then they have a formal meeting for some reason, and then they move on. So it doesn't really matter whether you have one or not. I think this government wants to show that it's taking its national security responsibilities more seriously. And many countries around the world create national security councils. One of the things they often do is to then create a national security advisor. And the advantage of that is that the U.S. National Security Advisor is probably the most important person in the U.S. government on national security issues. And that person needs a counterpart in other countries to talk to. So presumably Japan will create the head of the National Security Council, and that person will then be able to talk to Susan Rice in dealing with issues. Because it used to be that the National Security Advisor was just a White House official and didn't talk to foreign governments, but now they do it all the time. But there's no connection between that and the secrecy law. You can have a National Security Council, and of course Japan had a secrecy law. It was just tightening up the secrecy law. And I don't see any connection between the two except some notion that if we're a modern, efficient country, we ought to have a National Security Council and we ought to have a new secrecy law. On the question of the Marine base in Okinawa, there's no such thing, in my view, as need. If you ask the military about any base which they now have, they will tell you, quote, it is necessary. But it turns out we've closed a lot of bases. Subic Bay in the Philippines, for example, used to be the quintessential essential base. It turned out in that case, it really was essential because it had the world's best golf course. And the military fought the hardest for keeping that base because of the golf course. But the U.S. military took the view that U.S. sovereignty over Okinawa was essential. They said that in 1965. In 1967, they told the President of the United States that Okinawa could be reverted to Japan, consistent with American security interests. So if you ask the military, do you need a Marine base on Okinawa, the answer will be yes. If you say to them, tell me exactly what you do from that base on Okinawa, and tell me if I told you it was no longer tenable, how would you do those things? What other base would you use? And explain to me the degradation in capability or the increase in cost. It turns out every use of every military base can be substituted either in an increase in cost or a degradation in the function. It takes 3 days to do something rather than 2 days, or it costs $10 million rather than $5 million. So it is never, in my view, appropriate, and I went through this on every activity in Okinawa when I was in the Defense Department. It is never appropriate to ask the question, do you need a Marine base on Okinawa? The question to ask is, what are the functions that you perform on the Marine base in Okinawa? And for each one of those functions, explain how you would do it next best if you lost the base on Okinawa, and then specify either the increase in cost to get up to the same level, or the degradation in capability. And if it's a degradation in capability, explain the military significance of that degradation in the capability. My guess is that has not been done now for the Marine base on Okinawa, and if it was done, the answer would be a quantitative number. And then, in my view, you have to weigh that in a democratic country against the political price that you pay for trying to have the base or build a new base. And my view is, just as I thought that about Okinawa reversion, I don't think it's close. I think we should have long since given up the notion of having a new Marine base on Okinawa and paid whatever price, and I believe the price would be zero, but pay whatever price we have to pay in degradation or increased cost to do the same function someplace else.
I have a follow-up question to that, but I'm aware we're running out of time. Richard, did you have your hand up? Yeah. Well, actually, there's only 10 minutes left, so let's take your question, and then if there's a room, I'll ask.
Richard Lloyd Parry of the Times again. When you look at the character of the Japanese media, do you think Japan needs any secrecy laws at all? It sometimes strikes me that the best protection the Japanese government has of its secrets is the disinclination of the mainstream Japanese media to do any serious investigating at all.
Well, I thought the problem was that they wanted to be sure they remained in the clubs that covered the senior officials. I think it is hard to imagine a country that less needs a secrecy law than Japan.
Well, you know how all the Asahi and the Yomiuri, all the big newspapers are here today to cover you, right?
Well, no, I'm doing a press conference in the Japanese press right after this.
Oh, good. Okay.
We'll
Do you know
see
what
they say.
Oh, that'll be interesting. This gentleman here.
Süddeutsche Zeitung again. It's kind of following up. I would like you to speculate on what changes if this law is implemented. I mean, we have had the chilling effect forever in this country. We know whistleblowers. We have had several governments treated documents as private property and kept them secret. The latest was the one about the evacuation, possible evacuation of Tokyo. So does it make a change, especially since law don't mean anything in this country? They are there or not, they're used or not?
I think I'll pass on that question. I think it's a fair question. It still doesn't mean that one shouldn't fight and struggle against the law. I think it sets a bad precedent. It will affect the evolution of the country, but what practical effect it'll have, I can't really say.
Well, I'll ask my question if I don't see any hands. One of the arguments you hear speculated about in the Okinawan press is that one reason for this law is that the government is nervous about protests, any kind of information about what they're doing in Okinawa, but also on the outlying islands where there is a plan to militarize some of those places. That's an argument you hear in the Okinawan newspapers quite a lot. Do you think that's a credible argument? Because what I'm hearing, or what I think we're hearing, is that you don't actually know the reason why this law has been created, but it's certainly not for the reasons that have been given.
Right. I think, as far as I can tell, it isn't for the reasons that are being given, but I just don't have any basis for speculate. I suspect it's partly the same reason the National Security Council was created. It was a feeling that Japan had long since neglected the obligations of a country that took national security seriously, and it therefore needed to do a variety of things to show that it took national security seriously. And of course, the whole debate about collective defense is, I think, of a piece with that. So if I had to guess, I would guess those three things are part of a notion that Japan has rejected its responsibilities as a serious state that cares about national security. We're far enough away from the war. It's time we did things that everybody else has long since done.
Okay. We have time for one, maybe two more questions. Don't all rush. Gentleman at the back.
Andy Klein, WCN-TV.com. President Obama came into office vowing to be the most transparent president in U.S. history, but in reality, he's prosecuted more whistleblowers than all presidents previously combined. Right. Why do you think this is, and what is your take on Chelsea Manning's trial?
I think it's very hard to argue that Manning was a whistleblower. He, or now she, seems to have released vast quantities of information without even knowing what was in them. So unless the argument is that the government is not entitled to keep anything secret, I think that is, for me, a much easier case to say this was an inappropriate release of information. In fact, included among those documents was many reports of dissidents, political dissidents, coming into American embassies around the world to talk to people in the embassy about their struggle against the repressive government of the country in which they were living. And their names were in those documents, and those names were put online and jeopardized the lives of many people around the world. We don't yet have a case that we know of that somebody was injured, but in my view, it's a clear example of kinds of information that the government is entitled to keep secret and that people gave to the government with a clear explanation of secrecy. I don't know what the explanation is. It is true. There were 3 indictments of 2 of government officials and 1 of private citizens by all of the presidents before President Obama. And there were 6 indictments now by President Obama of government officials for releasing information to the press. It turns out when Obama was told this, he was startled too. So I am persuaded that it isn't a policy decision. That is, they didn't have a meeting either by the Attorney General or by the President and say, we're going to do this. I think what it is, and I spent a lot of time writing about this and researching and trying to figure it out. I think what it is this administration is determined that it's not going to be attacked by the Republicans for being not tough enough on anti-terrorism issues. And therefore, it came in and did 2 things. It ended torture, and it released the torture memos, and it's been since then engaged in an effort to make sure that the Republicans cannot use this as a campaign issue. And one way you do that is when you have your permanent career people who recommended many prosecutions to previous attorney generals, but Republican attorney generals had no problem turning it down. John Ashcroft turned down a number of requests from his career prosecutors, and he wasn't worried that anybody was going to attack him of being too soft and too in love with the First Amendment. I think this administration, this Attorney General in particular, are committed to the notion that they're going to show that they're tough on terrorism, that they protect the national security, and therefore when they're brought an indictment, instead of saying we don't indict people for giving information to the press, they said if this meets the standard of the statute, go out and indict people. And they've done it, and I think it has had a chilling effect. I think if you talk to reporters in Washington, unlike Japan, where you could argue you didn't need the chilling effect, in Washington, you did need it in the government's view, and we benefited from it not being there. It's gotten a lot worse. Now, that's partly because it's a lot easier to figure out who leaks things because they use email and because cell phones get tracked. In the old days, the government had no way to find out who had actually leaked something. But I think it's a real problem in the United States, and we're going to have to figure out a way to deal with it.
Thank you. Last question. Can you make it a quick one? Thank you. Sigrid.
Siegfried Knittel again. I think there is a great contradiction between the American praxis of, you said, what secret must be clear defined, paragraph by paragraph. I think this is totally opposite to Japanese bureaucratic thinking. They don't want to explain or define what's exactly. So how to deal with this?
Well, I think that's one of the faults of this law. It just enables you to take a whole document and say it's defense information, and that's the end of it, and then come back in 30 years, and if we think it can be released, we'll destroy it before we release it. And so I think that's a major, major problem with this law.
Okay, unless there's any more burning questions, I'll wrap it up, and we'll thank Mr. Halperin for coming today and giving us a very clear and concise criticism of the new law. We hope, well, many of us hope, I guess, that the law might be changed before it comes into effect in December. But if it does get used to lock a journalist up, hopefully he'll come back and analyze it all over for us again, perhaps in a couple of years' time. Thank you very much.
My pleasure.
Tradition of the club is to